League baseball player, Hall of Famer Wade Boggs. I also hope you listen to the Kelly Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is marine wildlife artist and conservationist Dr. Guy Harvey. Please listen to the Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
Tampa Bay's TAN Talk. Entertaining and informative radio for the Sunshine State.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right, and we are back live in the WTAN studio with FLA Law on the radio. I'm really excited today because we have a special guest, but before we get into that, my name is Jacqueline Bryan. As you know, I am one of the injury lawyers at Perinick, Caulfield, Averill, and Noyes, and we are here every Tuesday at 5 o'clock live on the radio to take your legal questions here as we are in the studio for the 5 o'clock hour. So you have 1 hour to call us and ask us any legal questions you might have pertaining to your legal matters. As you know, we are injury lawyers at Perinick, Caulfield, Averill, and Noyes. Today, I have another attorney here with me who practices in various other areas, and she's here to talk to you about something specific. But before I get into that, I'm going to give you all the call-in numbers and the places to reach us today because we're streaming just about everywhere. So the call-in number tonight, as usual, is 441-3000, 727-441-3000. That's the number that you want to call so you can get your legal questions in tonight. Also, if you are streaming and following us live on Facebook, we are live at Perinick, Caulfield, Averill, and Noyes Injury Lawyers. So if you want to find us on Facebook, that's how you can see the show. You can see us in the studio right now. And you can type in Perinick, which is spelled P-E-R-E-N-I-C-H, and you should be able to find us. Looks like we may have 1 or 2 viewers. Hello out there. Please share, like, comment. If you don't want to call into the radio and hear yourself on the radio, you can leave comments in the live stream feed. And my guest and I will read them and answer them on the air as they come in. So feel free to do that. We are also on Instagram. Hi, Instagram. It's too far away for me to see who's on, but if you are on Instagram, feel free to share our live feed as well, tag some friends. We want to get as much engagement as we can and answer all the legal questions as they come in. So if you have some questions on Instagram, we will read those after the break and answer those questions on IG as well. We also are on YouTube tonight on the WTAN radio station's YouTube channel. So if you're on YouTube, feel free to search WTAN and leave any questions or comments there. And our producer, Matt, will read those out to us so that we can answer those questions as well. So that covers all the socials. And I'm going to give you a chance to plug any socials or websites that you might have. But I want to introduce our special guest for tonight. So that way you don't have to hear my voice the whole time. Today, I have Sanatosha Sawar. I've been saying it wrong all this time that I've known her. It's Sanatosha Sawar, and she is a circuit civil mediator. And I'm going to give you a brief bio so that you know who we have in the studio with us today. And then we'll jump into some questions that you might have for me or her. And then she and I will just kind of have a conversation back and forth about mediation and her mediation practice and the different services that she provides. So let's jump right in. Sanatosha is a circuit civil mediator. She has a successful real estate practice and has been representing clients in a diverse array of real estate transactions for several years now. She graduated from FAMU and also received her law degree from Nova Southeastern. Some of the practice areas that she handles, in addition to mediation, is landlord-tenant, contract disputes. She also does foreclosure law and real estate closings. Sanatosha is certified by the Florida Supreme Court to practice as a circuit civil mediator. And so that's basically what we're going to be touching on for the most part today is her mediation practice. So without further ado, say hello to our audience.
Hi.
Don't be shy. They're not going to bite.
So, my name is Sanatocia Seward, just as Jackie just said. I'm the owner of Seward Legal PA, civil litigation and real estate firm, and I'm also circuit civil mediator. And I just wanted to come on today to talk about circuit civil mediation because a lot of people who have cases in this area, they're not aware of the resources of mediation during the process.
All right. Awesome. So before we jump into that, could you tell us, our listeners, where you're based out of? Where's your office?
So my office is in the heart of downtown Clearwater. It's 600 Cleveland Street.
Perfect.
It's in the old Bank of America building.
Okay.
So right in the center.
That's a great location. Yeah.
Thank you.
So downtown Clearwater is where you practice, but do you handle cases all over the state, or what's your practice area?
Yeah. Thanks to COVID, I'm able to handle cases all over the state. Okay. I'm able to have mediations all over the state virtually. So I was excited about that because, more cases come in that way.
That's true. And have you found, before we jump into it, have you found that people enjoy that? Is the virtual Zoom process?
Yeah, the majority of my practice is virtual.
Good.
I think they like it because they're still able to come. I have some people who, they want to come to the office. They want to see me in person.
Of course.
And that's fine. But the majority of them, they definitely just over the phone, Zoom call. Right. Yeah, they're comfortable that way.
Yeah, I find that some of our clients are like some of our attorneys, where it's just they like the in-person contact, want to meet you, want to shake your hand. And then you have a kind of a newer generation, I would say. They're like, if you could just text me, we would just be fine that way. So you don't even have to ever call my phone. So, all right, so let's jump into it, because a lot of our listeners may not even know what mediation is, what it's for, what it can accomplish. So can you just, start off telling us what is mediation?
Okay, so usually people would know. They are more familiar with mediation in the family law area and probably small claims. You'll always see mediation in those areas. But of course, we know traditional dispute resolution is to, go hire an attorney, file a claim, and then just follow, the legal system that way.
Right.
But mediation is an alternative to that dispute resolution. So, and not many people are aware of it. Usually we have a mediator, a neutral party. That would
like
be
yourself.
That would be me.
Okay.
I would bring the parties together. The majority of my mediations are Zoom now. So I would bring the parties together on Zoom. They're able to express or explain their position. Mm-hmm. Of course, they are going to be disputing, so they're going to have conflicting, positions. Once we get down to the issue at hand, I would separate the parties in what we call caucus. Yeah. Put them in two different rooms, and then I'll go back and forth from there to just get down to the main issue and see what would work for both parties.
Right.
So,
so are you on either party's side?
No, I'm neutral. Usually I don't even know the parties beforehand.
And that's what we tell our clients when we go into mediation, is that the mediator's role is not to take sides. Mm-hmm. They're there just to kind of almost be like a separate pair of ears and eyes, that they're not invested. They don't necessarily know much about the facts before they come into it. And so you would hope that they're going to see it the same way a person on a jury would.
Right. And I think that's the goal. I think that's what kind of makes it unique, because I'm a person that I don't know anyone, and I'm, just listening to the issues with a fresh, perspective. And then once I let them know if they're kind of going a little bit too far. Sure. But I think what makes it beautiful is when, the parties are willing to negotiate, and they're just willing they're willing to be there and compromise to come to a solution. So, and that's always my goal, to see what a good solution for both parties would be. And everybody's not going to get everything they want.
Yeah, you don't always get what you want. Yeah. I can't remember who says it now, but there's a mediator that I've worked with a number of times who says the sign of a good mediation is when both parties leave a little bit unhappy.
Oh, yeah.
So you didn't quite get what you wanted, but the other party probably did a little more than they wanted to as well. And so everybody kind of felt a little bit of a pinch, and that's probably a sign that you actually did compromise and reach a good agreement.
Yeah,
right?
And then the other side of it is nobody's leaving empty-handed either. So
you got a resolution to the matter, and that obviously is worth sometimes more than what you got dollar-wise or monetary-wise or family law related. So sometimes that's worth more than what you can even quantify. Is just getting it behind you and over with.
Yeah, definitely.
So generally I guess that explains the mediation process. Is there anything more that you feel the public should know as far as what goes into mediation? Can anybody attend or? Well,
usually the main parties attend, but some people need support, so they might bring family members. I'm okay with that as long as the other party's okay with that.
Right.
Some people even bring attorneys, even though they don't have to bring attorneys. But I'm usually, the good part is that it's a comfortable, informal process. So there's no rules as to who you can and can't bring. But there are a lot of benefits to mediation. The main thing is that you're controlling your outcome.
Right.
So on the other hand, if you go to trial, if the judge is going to rule, that's just it,
It's out of your hands at that point.
It definitely is. You're going to just get what you get and don't fuss a bit,
Pretty
But
much.
in mediation, you can control that.
Right.
And I think a lot of people, if they knew that resource was available, they would take that route.
Right.
You can control it. It's way less stressful. You're not running back and forth to court,
Right.
Which leads into a faster resolution. It's not 3 months to 3 years in court.
Yeah, because civil litigation can go on for years.
Yes, definitely.
And people don't always realize it when they get into it. They just know, I got an unfair offer on whatever my case was, and now I'm going to take them to court and litigate it. But they don't realize that this could mean years of your time.
Oh, yeah, definitely. Which in mediation, it could be a few hours or just a few days.
Right.
So, of course, that goes to costs.
Right.
But, and then, of course, with mediation, you can save relationships as well. So, you have issues with friends and coworkers and things like that. With mediation, you might come out still being able to save the relationship of the two parties as well, versus in court.
Right.
Is less likely to save that personal relationship. And then we also have the confidentiality of everything. It's still confidential. You can't take what we discuss in mediation to court.
So I guess that brings me back to who can be there. So when you're dealing with a confidential matter as a mediator from your perspective, does that complicate things when they bring their aunt or their cousin or the girlfriend or the boyfriend? Do you feel like that complicates the confidentiality issues or getting to some sort of resolution when they have more people there with them?
Well, what I like to do is make them sign a confidentiality agreement.
Okay.
I know that I'm going to be, confidential, but when you start adding people to the party, it could possibly bring in some So I like to make sure they sign a confidentiality agreement when they come in.
And people don't always appreciate, and I can only really speak from the personal injury perspective. So forgive me if I'm not really as learned on how other mediations work. But from the personal injury perspective, I feel like people don't realize if you go out of mediation and discuss what happened, let's say you settled it and you got a good settlement and you were happy, and then you go home and tell, Papa Joe and whoever what happened. If the defense finds out about it or somebody posts on social media about it, that settlement that you just got that was so great might be gone now.
Yeah, because you just broke confidentiality.
Exactly.
So that is definitely important to just, if I was anyone coming in, I would definitely keep it, personal because they might have given you that great deal. They might not want everybody to know, to know about it.
Because they may not do that for everybody and any other parties.
Definitely.
And they want they don't really want people to know that they've been sued either, even though a lot of that's public record. But there's a lot of reasons and basis for it. And in mediation, you should try to negotiate more for that confidentiality.
Oh, yeah, definitely.
But, people don't always, they brought people with them. That person said something and got back to, the wrong people. So confidentiality of mediation is really, really important.
Oh, yes, definitely.
Yeah.
Another thing is a lot of people don't know the areas. Like you just mentioned, personal injury. They don't understand. They don't realize that mediation, you can. I think what. So for me, because I do a lot of real estate, I actually slowed down on foreclosures because I get attached to my clients. But
I mean, I think we all do to some extent.
Yeah,
we're not supposed to, but you just have those ones. Yeah.
Mm-hmm. So what I like to encourage people to do, especially for foreclosures, is always seek mediation. A lot of times they don't know where they.
So it's not required in foreclosure cases to go to trial.
It's not required for mediation, but you can always ask. You're not always requested.
The only reason why I asked because I think in the Sixth Circuit on like PI cases, before they'll even let you get a trial date, you have to mediate.
Yeah, and that's the same way with small claims, same way with family law. But foreclosures, no, they're not always
interesting.
I know, right?
That.
And so
those would be the main ones you would think you would try to want to sit down and resolve it. People's homes are in the balance.
Yes,
and,
their homes, their lives, everything's kind of torn apart. Yeah. And a lot of times they just don't have the funds to fight it. They don't.
Right, exactly.
They can't hire an attorney.
If they had the money, they probably wouldn't be in foreclosure. Right.
Thank you. So that's why I try to encourage when they, come to my office. I try to encourage the mediation route because you're going through it anyway. You might as well try to, especially if, you got a new job, you were able to get a new loan or something like that.
Keep going.
Okay. So, and a lot of times the opposing party or the bank, they're just not willing to speak with you privately to,
So when the banks come to mediation, this is kind of getting off topic of you as the mediator, but I'm just curious. So when banks come to mediation, do you feel like they're receptive and they try to get something done or they just breeze through it like a formality?
Yeah, I think that they'll try to get something done, especially if you've come upon a new resolution.
Okay.
So for instance, if you were able to get a new loan or something like that, or you got a new job and you just fell behind.
Some new information comes to light that they weren't really aware of.
Right.
So they'd be more likely to work with you.
Yeah, they are. And then also, if a case has already been filed against you, you can file it. You can file the request in court, so the judge will know.
Okay. Well, Tosha, it looks like we have a caller on the line. I think we have Jacob from Largo. Jacob, are you there?
Yes. Thank you very much. Very good show.
Thank you. Go ahead with your question.
I really have two questions. Who picks the mediator and who pays for the mediator?
That is a great question. So
thank you, Jacob.
Yeah, thank you. So both parties will agree on a mediator. So you can always put your suggestions in and then the other party will agree or otherwise. And then as far as payment, which I think is the best benefit, I didn't touch it yet, but the parties split the fees right down the middle.
Okay, 50-50.
So they split it 50-50. Sometimes I might even have three parties. So they're splitting it three ways.
More divided up. Yeah, that's good.
Yeah. And then so, in like traditional, of course, everybody's eating up their own fees until somebody wins.
Right.
And then they can do, attorney's fees and the loser gets that.
Right. Because you go all the way to trial.
Right.
No one's going to split the bill.
Right. No one's splitting the bill into trial. Yeah. So you're eating up your own fees. Everybody's eating up their own fees. But in mediation, once it's done, the mediator splits it down the middle, bills everyone equally, and everybody kind of goes home from there.
Okay. Does that answer your question? So it sounds like you coordinate with the other side. You coordinate together to pick the mediator, and then you split the costs.
Mm-hmm.
That sounds like great. Thank you very much for your help.
Thank you.
Absolutely. Thanks for calling.
Great show. Bye-bye.
Bye-bye. So that frees up a line if we have any other callers that are enjoying what Attorney Tasha Sawar is saying tonight about her mediation practice. You have questions about mediation. Maybe you've got a notice that one's coming up. You've been scheduled for one and you're kind of freaking out about it and want to know what should I expect. or any other questions pertaining to mediation of how it could benefit you or why you might want to retain attorney Sawar for your mediation, feel free to give us a call. Again, that call-in number is 441-3000. 441-3000. That gets your call right into us at the station. And we are still streaming live on Instagram and Facebook, so you can drop a question in there as well. So that was good. I like that he asked about who chooses the mediator. Mm-hmm. So at the end of the day, if someone wanted to retain you, they can obviously throw your name out there, and the parties kind of will vet and decide if they want to go with you or somebody else. Is that how that works?
Yeah, usually when it's time to choose a mediator, of course, both sides will put the mediator forth, and then they just agree from there.
Okay. Yeah. So what if we can't decide? Then how does the judge have to pick, or
the judge can definitely pick? I know that in certain cases, the laws are different in certain areas. Sure. But I know for a fact that there is a rolling list, but the judge will just give you any mediator. So I think it's kind of more beneficial.
Yeah, it's beneficial if you could figure it out than getting stuck with somebody you don't really know and if they can be effective on your case. So unfortunately, I can't go in and pound the table and say I want Sanatosha.
I wish you could.
And I demand that she be my mediator. I don't know if that'll work, but of course we can always put your name in the hat. So that's good to know. I think it's time to take a quick break. We'll just take a quick commercial break and give people time to call in if they'd like. Again, that call-in number is going to be 441-3000. We'll take a short break and we will be right back here with Circuit Civil Mediator Sanatosha Sawar, and she will be answering a few more questions about mediation before we wrap up the show. Call us soon.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
All right, folks, we are back with FLA Law live in the studio. Back again from break with our special guest tonight, Sanatosha Sawar. She is a circuit civil mediator who mediates all kinds of civil matters in the state of Florida. She has already touched on quite a bit. So we wanted to just kind of dive in and finish up her interview here in regards to her practice of mediations, how you can benefit from them, what areas you can kind of use them in. It may not apply to all areas of law, but it does apply to quite a bit. So I'm going to allow her to kind of discuss some of that more. And of course, as we go on, if you have any questions for Attorney Sawar and you would like to call in, the number is 441-3000. And again, we are streaming live on YouTube, Instagram, and Facebook. So feel free to message us and we will answer your questions here live in the studio. So before our break, we did kind of touch on the process as far as how long it takes. And, mediations obviously are the parties coming in, sitting down, trying to get their issues resolved. How long does that generally take? And, what amount of time do you think we should dedicate if we're going to be going into a mediation?
So what I like to do is just block off a 4-hour block.
Mm-hmm.
A lot of mediations, it really depends on the parties.
Sure.
I have like insurance claims, they might just last an hour
Yeah.
versus a PI claim might last for a couple of days.
Sure.
So it really depends on the parties. It depends on how much evidence they want to introduce.
Mm-hmm.
It depends on how stubborn the parties want to be,
Yeah.
you know? So it really just depends. There's like no set, but I don't think I've had anything that went on for weeks. You
Right.
know, it's really, I don't think it would last that long.
So then obviously people are like, well, what's going on during that time? The majority of that time frame is not the opening caucus where everybody's sitting together, right?
No.
That's more so the negotiating back and forth part, right?
Yeah. So at the beginning, when everyone's giving me they're literally giving me just a brief, like a overview of what the issues are.
Mm-hmm.
And then from there, we usually split because when they're giving their briefs, of course, the other party's not agreeing.
Yeah.
You know,
Yeah.
they're not going to agree. So
typically, I always tell my clients, when I'm giving my opening, you're going to likely agree with everything you hear me say. When the other side starts talking, you're probably going to disagree with everything you hear them say. Just don't let it show on your face.
Right. So once they both give me their sides, I'll break them up from there. That way we're not having the bickering and, arguing and over talking.
Yeah. Mm-hmm.
I usually, that's in my opening.
Mm-hmm.
I don't allow it
Mm-hmm.
at all.
Yeah.
Because we can't come to a resolution.
It's not productive.
It's not productive at all. So once I separate the parties, the majority of it, it's just like you said, I'll go to one party, they'll explain their position, give their demand.
Mm-hmm.
I'll go to the other party, explain the previous party's demand, and then we'll just kind of go back and forth from there.
Right.
So
I've rarely had this happen, but every now and then some mediators do it. Do you feel like when it's going long, like so one of those hours or days long mediation that you mentioned, is it good to have everybody come back together sometimes and do the caucus again? Or do you feel like once is enough, we don't need to bring everybody back together again?
I kind of go with the flow of the parties. I've had times where they would say, we can come back together and talk. And then I've had times where only their representatives might say, can we talk together?
Yeah.
Oh, I'm sorry.
It's okay.
The two representatives.
That was the microphone.
Yeah, that was the microphone. They might say, can we just talk together without our clients?
Yeah.
And they'll come to a resolution that way.
Yeah.
So I usually just kind of go with the flow of things. I'm not saying, no, we have to do it this way.
Sure.
I just kind of go with the flow of the party. So so everything can kind of just be calm and relaxing, and we're just talking to come together to solve the issue.
So I guess I want to know, what are some of your tips for people who are going through this process and they are a little worked up or agitated, or if it's a sensitive subject, sometimes it's custody or divorce. That's exactly why I don't do family law.
I was just,
but emotions can run high.
Oh yeah.
So in my opinion, that can sometimes be a deterrent to getting the case resolved. So what do you feel is a good tip or advice for people that are going into mediation where it's a emotionally charged issue?
Okay, so first thing, I don't do family law either because of that reason. But I do have cases where the parties are already riled up before mediation.
Oh yeah.
So when that happens, I don't do I just do my opening separately.
No
They're
caucus.
Already in caucus.
Oh, okay.
Because caucus is the separation.
Right. So no openings. Okay.
Yeah,
I said that wrong. I apologize.
We just don't come together. As soon as they come in the mediation, they're already separated.
We do waive openings a lot in workman's comp.
Yeah.
So not necessarily because the parties are upset with their employer, but just because I think it streamlines the process. So it's like the mediator can come in and speak to everybody individually. There's no need for us to kind of have that banter back and forth. We just kind of get to the issues. What are the issues? And we kind of just get straight to it. And I think some clients sometimes appreciate that. Yeah. And they're like, I don't want to sit across from them. They didn't do right by me. Right. They didn't give me the benefits that I deserve. Why should I sit there and listen to them? So sometimes I think that actually is good. Yeah.
But I just kind of let them choose that. If they come in and say, Attorney Seward, I don't want to see them, then I'll just start off in caucus. Then I'll just do 2 openings. That's okay with me. Yeah. And I just kind of really just go with the flow of, the parties.
Okay. Well, that makes sense. And so obviously, depending on, how well people respond, then that can also determine the length of how long the mediation is going to go.
Yeah. Sometimes I even have to where they don't even want to go into caucus. They'll come in, they're ready to negotiate already. They're calm. They're just having a disagreement on how much I'm owed and how much I'm going to give you. It might be one of those situations.
I thought you were going to go the other way with that. I thought you were going to say they came in, they did not like what they heard, and they were ready to walk out. Like, okay, we don't need to caucus. I'm done.
Hey, I think I've probably had at least one of those too. But I do have. Sometimes I might get very open parties, and they're just come in and they're just ready to negotiate in a happy way, and everybody's happy.
Right. So obviously, I know we're going a little bit off, but what is your general open that you share? Like, what would you tell the public when they're coming in, never mediated before? How do you kind of explain it, like, to get them kind of calm and to be receptive to the process?
Okay.
You don't have to give me your whole opening,
I'm not going to give you.
But I'm curious as to what you feel is effective.
So I usually let them know that I'm an attorney, but today I'm not your attorney. I just serve as your mediator. So just to let them know, I'm not choosing a side. I'm very neutral. I let them know about the confidentiality. I let them know what my rules are as far as over talking and being loud and things like that, because we can't come to a resolution that way. Right. I also let them know the process. So just so they can kind of be a little bit more comfortable, I let them know I'm just going to take your statements. If you don't want to talk, you really don't have to. It's beneficial to me if you do, but if you don't, that's okay. And then we break into caucus if you want to do that. If you don't want to do that, that's fine as well. Right. And then I also let them know, just because I'm the mediator, it doesn't necessarily mean I need to be there with you when you're speaking with your client. Sometimes they think, she has to listen, but I don't. I can step out and give you your privacy if you need that. Sometimes they want to make a phone call to their company. It depends on the case, So I just kind of, the same way I am now is the same way I go into mediation. I'm just calm. It's nothing formal or anything like that.
Right. And so I think that people don't always realize either that as the mediator, they can kind of speak freely because it is confidential. So it's not like you're going to go back and say things to the other side that you're not authorizing them to say. So I tell my clients that a lot is like, although we can certainly speak outside of the presence of the mediator, and sometimes I encourage that, but for the most part, you can speak freely in front of the mediator, because it's, your job to get all the facts and the information and understand that client's perspective, but you only share, what we're telling you to share to the other side. Right. And
I always confirm what you want me to share.
What do you want me to tell them?
Yeah, because a lot of times they're just going. They're just telling everything. And before I go back over, I'm
how much of that do you want me to actually say?
Do you want me to share this, and this? And they might say, no, don't share that. Only share this. And that's the only thing I share. Right. So I try to, just be very ethical about my entire mediation process and make sure everyone's comfortable with what's being said, what's being passed along, and what they're agreeing to as well.
Exactly. So then do you find that people believe that to be true, that they believe that you're not sharing information, or you can't really gauge on that? Because I feel like sometimes people are still skeptical, like, I don't know if she's really keeping our conversation in confidence, or if she's trying to use it over there to get the case settled or not.
Well, I think that, to me, first of all, I feel like if I share too much, the other person is not your friend or my friend. Right. They will throw that back in your face as soon as they can. Yeah. So I definitely don't share anything I'm not supposed to share. And then I don't want to get in trouble either for sharing things I'm not supposed to share. So they may be skeptical though. You can't.
I see that sometimes, and I don't know how you really get around that. But I think if as a mediator, your temperament and the way you deal with the client, I think will help them realize that she's just here to try to help us, and she's not on anybody's side,
Right,
So
right.
you get paid regardless, right? So going back to that, we touched on it with our caller who called in with a great question about how the mediation is paid for, but fees wise, what could someone expect? I could say, I wanted to hire you on a case, or a party that is unrepresented wanted to hire you, and they got the other side to agree to it. What could they kind of expect generally?
So I would say, for instance, and I'm going to give the other side just so you can kind of have perspective.
Mm-hmm.
So, in the traditional conflict resolution, going to court and going to trial,
right,
you're going to pay your attorney's fees, and then you're going to pay court costs and fees. And then you're eating that the entire time. An attorney is probably on average about $300 an hour. And then that's over time. So it just depends on how long out that goes.
Exactly.
And then for a mediator,
it could be thousands and thousands of dollars.
Easily
especially in
thousands.
PI cases when you've got to pay doctors and oh my gosh.
Yes,
but anyway, I digress.
Easily thousands. Well, mediator, you might have the same hourly rate, about $300, but it's only for a day or two.
Right.
So that kind of puts it in perspective as to your costs.
Right.
Instead of you dealing with $300 an hour for months or years, you're only dealing with the $300 for a day or two. And then you split that down the middle. So,
which is awesome. Yeah. Like I said before to the caller, when you're going to trial, you're not splitting anything. Now, maybe at the end, if you prevail, you can get the other side to pay some taxable costs. But if you don't prevail, you just ate that huge bill, and something that could have been maybe resolved at mediation for a few $100 has now cost you thousands of dollars that you have lost. So looks like we have a caller on the line. Sanatosha is excited about that. Jonathan, are you there? Can you hear us?
Yes, I am here.
Hi, how are you? Go ahead with your question.
Good. I have a question because I heard both of these terms, mediation and arbitration.
Mm-hmm.
And can you explain to me what the difference is? Because I thought they were basically the same thing.
Oh,
no, not at all.
Yeah.
Did you want to tackle that?
Yeah, I'll tackle it briefly. So with mediation, the parties decide whether they decide the outcome. So whatever the parties decide, that's what they're going to do. Even if we are at an impasse, which means there's no resolution, we're just going to move forward and just go file a case in court. That's their
go to trial.
That's their prerogative. They get to do whatever they want in mediation. Arbitration, on the other hand, there's an arbitrator that's going to make the decision for you, much like when you go to court and you have a judge there.
Right.
So, and the decision that the arbitrator makes is basically set in stone, just like it would be for a judge if the judge would make the decision for you. So in mediation, you get to control it. In arbitration, not so much.
Right. So the power is more so in your hands as a party to kind of control the outcome that you get. In arbitration, it is in that arbitrator's purview to decide what you should or shouldn't get. And a lot of times it is binding, like Attorney Sawar said. Does that answer your question?
Yes, that does. I just didn't really know the difference. I've heard both terms, so thank you so much.
You're
that definitely cleared things up for me.
Absolutely, and I'm sure Sanatosha would agree that mediation is the better route, right?
Yeah, I would.
Stay away from
agree.
Arbitration. Thank you, Jonathan. You have a great night.
You too.
So that does free up a line. If anybody else has any great questions like that out there, you can continue to give us a call here at the studio. While we have our guest here, it's 441-3000. Again, that's 727-441-3000. Great questions so far. Again, we're also on the socials if you want to drop a comment there. So we were obviously in the middle of talking about the cost. So I think that does kind of sum it up, though, for the most part, is that it is an hourly fee that you're paying. It gets divided by the parties equally. And it's a lot cheaper than arbitration or trial.
Yes.
So, okay, so that's good. So I know we had touched on a little bit of the practice areas that you do. And before we get into a list of it, you mentioned small claims a couple of times. Do you handle mediations in small claims court?
So small claims is a little bit different because the mediators are usually in court. When you go, they're already there. It's like a slew of mediators. The cases are going fast. They call your case up. If you say, yes, this is my debt or whatever, you just go straight to mediation right there in court.
Right.
The areas that I've mentioned for circuit civil, which, another thing too is county mediators. They take everything $15,000 and less.
The jurisdictional limits apply.
Circuit civil mediators take everything $15,000 and more. So when you're dealing with small claims, that's $8,000 and less.
I believe so. Yeah.
So they have a lot of county mediators there, and they just take you right straight to mediation there while you're in court.
Right.
So that's pretty much the difference between small claims and then the areas that we've mentioned.
Right.
So
then, and this may be totally off topic. So if you go to small claims and you mediate, it's not like what we've been talking about where you get to choose and select a mediator, you pay hourly, split the bill. That's something totally different on small claims.
That is something totally different when you're
so you know out there, it's going to be different if you're in a small claim.
Yeah, and then the mediator is free. In small claims.
Exactly.
It comes with your case.
Yeah. So if you are at a small claims hearing and the judge orders you to go directly to mediation, don't think you're going to be paying $300 an hour. Okay?
Right. And so, you basically pay for them when you did your court.
Yeah.
When you did your court
your filing fees.
Yeah,
right.
when you do your filing fees. But circuit civil mediations usually fall under the area of personal injury, business and commercial law, real estate law, construction, intellectual property, environment law, healthcare, education.
Let's go back to healthcare. What kind of healthcare claims are you mediating?
So between patients and healthcare providers, and then between healthcare providers themselves.
Oh, I see.
Yeah.
Okay.
So anytime you have a dispute, you can mediate it.
Got it.
Yeah. And then you also have education and then employment law as well.
Awesome. And you handle all of the above.
Yes.
Awesome. So obviously that kind of covers the gist of most of our questions that we had together. But I want to give you an opportunity, obviously, to let the public know where they can find you, how they can locate you, so that if any of our listeners want to retain you in the future, they know how to.
Awesome. So if you're not sure, if you have a legal issue and you're just not sure if it can be mediated or if it falls within one of those areas, you can definitely call my office. We give free mediation consultations just so you can figure out if you should go to mediation or not. And you can reach me at my law firm's website is sewarlegal.com. That's SEWARLEGAL.com. And then the phone number is 727-437-1511.
So you heard that, guys. Free mediation consultation. So if you are not sure if your case is right for mediation or if it's something that needs to be mediated, you can reach out to Sanatosha Sawar about that, and she will actually meet with you for free. I did not know that until just now, so that is amazing. Give your website one more time and phone number so that the callers hopefully can take it down. If you're driving, do not write and drive while we're doing this. Go back and watch one of our live stream videos and get it that way. But go ahead and give that information to them again. So it's Sewar Legal,
SEWARLEGAL.com. And my phone number is 727-437-1511. And I also want to say, because I'm an attorney and I'm a mediator, I can't be both for you. Right. So you would have to choose. So if you hire me as your mediator, unfortunately, I can't go back and be your attorney. Right. But yeah.
So that's a great point. And we've been kind of touching on it back and forth that this attorney Sawar does practice law as well. So she does handle legal matters. Although we've been talking a lot about mediation, if your case is one that goes to mediation or should be going to mediation, you cannot hire Sanatosha to also be your mediator if she's representing you for that legal matter. So it's one or the other. This would be a situation where you've already have a lawyer and you're moving forward with the case and you know that mediation is coming, or you think that it might be a good time to do it. You could always call your lawyer and say, hey, I heard this great mediator on the radio tonight and she sounded wonderful. I want you to put her name in the ring when it's time.
Or if you're pro se, if you're by yourself,
or if you don't have a lawyer, right? And you're not represented by anyone. She can't represent you and mediate, but she can do one or the other. Now, that brings me to a good point before I let you go. Do you want to touch on any of the practice areas, at least just let people know what they can retain you for outside of mediation?
Okay, so the service areas that I represent so far is real estate law, landlord tenant, debt collections, probate, and circuits of a mediation. So basically, if it falls under any of those, and of course, civil litigation's in there. So anytime you're fighting for money or someone owes you money, you can call me.
Right. And so I mentioned it earlier, but she told me she's moving away from that. So foreclosures, foreclosures, she's moving away from it. That's something that she is not doing as much right now. So don't call her for that. Although I did say that in the beginning, I was wrong. But of course, mediation is kind of what she's focusing on now. So that is amazing. I want to thank you so much for coming in tonight. I think that was great information for our listeners. We are going to take a quick break and our guest is going to leave. Is there any parting words that you have before we go to the break?
I hope that everyone learned something new today.
Yeah.
I enjoy speaking about mediation.
Absolutely.
And if you do have an issue that you feel can be resolved in mediation, you just don't want to keep dragging it on, just definitely give me a call.
Absolutely. Give that phone number one more time.
It's 727-437-1511.
Awesome. We are going to take a quick break. We'll go to commercial, then we'll be back for some closing words from me. Thank you.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman. In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perinick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the TAN Talk Radio Network.
We are back live in the studio for the last few minutes to wrap up from that great show. We had attorney Sanatosha Sawar in here giving us all the scoop on mediation. If you have been through a mediation or have a mediation coming up, hopefully that was some good advice and some tips from her. We had some great call-in questions as well about mediation. So like she said, if you have a civil lawsuit of any kind or dispute, then you can expect that mediation may have some part or some role in that. From the personal injury perspective, I can tell you some of the advice I give my clients when the mediation gets scheduled is, just stay calm. Be cool, keep a poker face. You don't want the other side to see you sweat. At the end of the day, you are there to try to get the case resolved. And if emotions are running high and you're unhappy with the offer that was made in your case or the situation that's going on in your case, it's best not to let it show. I find that people tend to get in the way of their case resolving when they're overly emotional about what's going on at the mediation. So if you have a good mediator like our guest, who is able to inform you on the process, how it works, what we're there to accomplish, hopefully that'll keep you kind of calm and cool and collected. And you listen to your lawyer. Some of the mediations that I had earlier on in my career, when I wasn't as experienced, the client sometimes would get upset and it was hard to wrangle that in. So as a client, you want to listen to your lawyer and make sure that you're staying calm, you're staying cool and collected, and know that the other side is there evaluating you as well, just like a deposition. So they're looking at you to see, is this someone that we want to resolve the case with, or do we want to take this all the way to a trial in front of a jury or a judge? And if you show that you're easily ruffled and your feathers are ruffled easily at the mediation, then they might decide, hey, we'll take our chances in court. And so it's best to kind of put your best foot forward, dress nicely, appear presentably, be kind and courteous to the other side. Even if you disagree with what they're saying, you don't have to be their best friend, but you also want to present yourself well at a mediation. And so that was some great tips that we got from our speaker tonight, our guest. And I hope you were able to learn some things from that as far as her services. And like she said, it's not just personal injury or negligence cases, but it could be anything as far as real estate disputes or foreclosure disputes or any type of issue that may need a mediator. Family law is also one that typically needs mediation at times when there's custody battles or trying to dissolve a marriage. At times that can be contentious, so mediation can come in handy. And like she said, I think the biggest takeaway is when you're going to trial, you've got to pay a lot of people, a lot of experts. You've got all kinds of doctors and people that come in to testify on your behalf, and they don't do it for free. It's very expensive, and you're paying them by the hour. And, by the time you get to a jury trial and you're ready and teed up to go in front of the jury, you could be looking at thousands and thousands of dollars. And so if you compare that to a mediation that may be $500 or $600 for your fee or your share after it's divided up, I'd say that's a lot better than going down to the courthouse and taking your chances if it's all about cost. But sometimes The insurance companies don't leave us any choice, and we have to try cases. And we do try cases at Pernick, Caulfield, Averill, and Noyes, personal injury lawyers based out of Clearwater. We have offices in St. Petersburg and also in Pasco and Hillsborough County, but we do handle cases all over the state, and we are trial lawyers. Several of our attorneys are board certified trial lawyers, which is only 3% of lawyers in the state of Florida have that distinction. And so if you find yourself in a civil matter that needs to be tried that's personal injury related, give us a call at 727-796-8282. This has been another wonderful show at FLA Law Live on the radio. See you again next Tuesday at 5 o'clock. Thanks, everyone.